Hello, everybody. It's attorney Laura Sterling. Welcome, welcome, welcome to my live show. I hope you're comfortable. I hope you're ready for the live show. I usually like to spend the first 5 minutes just kind of chit chatting with you all to give everybody an opportunity to log in and get into the system and be able to watch me both on Facebook and as well as YouTube. So, and please know if you're watching me and you have questions, just put the questions in. That's what I'm here for. And that's what we're here live for, is so that we can answer your questions directly. Now, remember, as I always like to say at the beginning of my live shows, I'm an attorney licensed just in the state of Florida. I can't answer questions if you live in Wisconsin or Wyoming or Washington. I don't know why I picked all the W states, but I cannot answer questions for any other state than Florida. What I would advise you, if you're watching and you don't live in Florida and you have questions, is to seek an attorney that's in your state that practices in this area. Like today, we're talking in family law. We're going to talk about family law issues. So it'd be good to find an attorney that practices family law to answer your questions. And please don't look for the answers to your questions on, Google Esquire, because Google is very general. People always come to me and say, "Oh, say the internet said this." And I'm like, "No, but it's not right. It's general. Google is very general. I mean, you wouldn't look up if you needed heart surgery, you wouldn't look up heart surgery. Oh yeah, I can do this. No, you'd go to a doctor to get that information. So the same thing with anything legal is please seek the advice of an attorney before you do anything. So just to make sure that you're doing it right or you're getting everything that you need, because especially in family law, people, they agree to things. One spouse says, "Oh, don't worry, just sign this, but don't worry, I'll do this." Well, then you sign it, you get a court order, and it's finalized. And now your former spouse or former partner is not following what they told you they would do on the side, because on the side is not legal. In fact, I had a client today that said, "Well, I have a text message from my wife where she agrees to X, Y, and Z." Good for you, but until there's a court order, that's not really a legally binding issue. I know you watch Judge Judy, and Judge Judy likes to look at text messages and stuff for an intent. But in family law cases, it's different. So we want to make sure that we always dot our I's and cross our T's and get you the best that we can get you in regards to your case. Because when there's children involved and, things and stuff, I like to call them, your equitable distribution, your property, your liabilities, child support, alimony, all of that you have the advice of an attorney to make sure that you're getting what's rightfully yours and what's right and just. I always tell my clients in family cases, at the end of the day, if you agree to something, I'm not going to say agree or don't agree. I'm going to tell you, if you go to court, this is what's going to happen. But know that in a separation, a divorce, or maybe you guys were together and you have a child together or something, you may not always be 100% happy, but if it's something you can live with and something you can deal with and you can co-parent or do whatever you need to do with your former partner or spouse, then potentially you've had a victory. So I always tell people it's always best to try to settle rather than have a stranger in a black robe sitting up on we call it the bench, doesn't know who you are, doesn't know anything about your history, is just being given a few hours of some evidence and testimony, and then deciding your future based on that. So it's always better to settle. But again, if you can't settle, you can't settle. And it's best to go in front of a judge. So Okay, well, we're at 2:05. At least that's what my clock says here in the great state of Florida. So I'm hoping that everybody that's logged in. And please, even if you come later and you have a question, no problem whatsoever. So please make yourself comfortable. Make sure you're in a nice, comfy chair, whatever you do, that you can hear me. You have the volume up. Maybe you have your little pen and paper, however, you're going to make notes. You have your little drink. I have my little waters here because I'm the one that's talking a lot. And if you have a little snack, just make sure that you're getting everything that you need to get. And again, we're here to help you. If you just want to call the office and talk to me individually. Anyway, as I've been leading up, it is the month of April. The year is flying by. The month of April, we're going to talk about marital settlement agreements. Remember, at the beginning of the month, I said, okay, we're going to be talking about marital settlement agreements. What is a marital settlement agreement? Now, remember last month, the month of March, I talked about parenting plans. And parenting plans are a roadmap of how, now that you're separated, but you still have this living human being that you have to raise called a child, the parenting plan is a roadmap for you to co-parent. Well, a marital settlement agreement, in my eyes, is a legal document that outlines the terms of your divorce, because you have to be married to have a marital settlement agreement. So for me, it's a roadmap of how you and your former spouse are going to divide your assets. Potentially, if you have children, how are you going to pay child support? Alimony, attorney fees, all of that. And we're going to talk about that today. But I just wanted to kind of introduce that marital settlement agreement. Now, the marital settlement agreement, of course, can be something that you and your spouse draft on your own. I would not advise that. I cannot tell you how many people have come to me with this marital settlement agreement that they agreed to on their own with their former spouse. It's been filed, there's a court order, and now they can't abide by it, or they can't do it, or it doesn't seem fair, or it doesn't seem right. Once that marital settlement agreement is signed and in the courts and there's a final judgment, it's very difficult to change it. There has to be what we call a significant change in circumstance, and that can be very difficult. So it's always best beforehand to have the marital settlement agreement drafted by an attorney. So with that said, let's dive right into what's contained in a marital settlement agreement. Well, first of all, let's start with something we call equitable distribution. I'm saying these words kind of with an emphasis so that you learn them. Because if I just said equitable distribution of your assets, that may flow out of your head. But equitable distribution talks about the equitable distribution of the assets and the liabilities in your marriage. So, what do we consider as marital assets and how do we divide them? Well, think about it this way. Let's talk about first how the court divides marital assets. I always put it very simply. Pretend like there's a big bowl and all your assets and all your liabilities get put in there. We stir it around and the court's going to divide them. Now, this is, of course, if you go in front of a judge. These are things that I'm talking about if you go in front of a judge. A marital settlement agreement with equitable distribution can be any way you want it. The court will not look at a marital settlement agreement and go, wait a minute here. I don't think that the wife should get the house because, well, she really didn't do much to the house. That doesn't matter. In a marital settlement agreement, meaning the two of you come together and agree on how to divide your assets and liabilities, a court won't touch it. A court really won't touch it because equitable distribution is about your things and stuff, and who's better to decide your things and stuff than you are. So what I'm going to talk about is, okay, you tried to do a marital settlement agreement and you couldn't. So how would the court look at an equitable distribution of your marital assets and liabilities? So this is what I always talk about in a mediation. There's a marital settlement agreement on the table. I say, okay, this is what would happen if you went to court. So the court looks at distributing assets and liability in an equitable manner. Now, what does that mean? Generally, what it means is fairly. And how does the court look at what's fair and what's not fair? Well, they look at some factors. They look at the contribution to the marriage of each spouse. Did one spouse stay at home while the other one worked? Did one spouse encourage the other one and get them to a place in their business, maybe CEO or CFO, or owning their own business and making millions, and allowed them to do that while they stayed home, took care of the children, maybe took care of the home? And what was the interruption in that spouse's educational career or their work performance as well when they decided as a couple for one person to stay home? Now, I get this a lot where one spouse will say, well, I never agreed to let them stay home. Or the other spouse says, well, they never let me work. It doesn't matter. It doesn't matter. One of you stayed home, one of you didn't. So they look at that factor. They also look at the economic circumstances of the parties. What is it right now? After the divorce, what is it going to be? If one spouse worked and made $200,000 a year and another spouse just did a little business on the side and only made $15,000, they're going to look at that. The duration of the marriage, and we'll talk about that when we get into alimony. How long was this marriage? Was the marriage short term? Was it long term? Was it moderate term marriage? We'll talk about that more in alimony. So they look at the duration of marriage. Like I said, any interruption of any personal careers or education, the contribution of one spouse in allowing the other spouse to get an education and become more marketable with their positions. What about the acquisition or the contribution and the ability of one spouse to get more assets or to acquire more assets or to take care of those assets? Maybe the desirability of one spouse to maintain the marital home. Maybe there's minor children and they want the children to kind of grow up in that home, stay in the same school district, and have as little change as possible. So those are kind of the factors the court looks at and kind of equitably distributing those assets. However, there's also a little caveat in there for the court to say, I'm not going to award an equal distribution. I'm going to give a little bit more to one spouse. And what would that be? The intentional depletion or dissipation of any assets or liabilities, either during the pendency of the divorce or 2 years prior. Now, I've had one where it was an unequal distribution because I was able to prove the husband throughout the marriage, and it was a long-term marriage. This was no short-term marriage. Throughout the marriage had depleted, dissipated everything. He had even had his children, when they were in college, get out student loans in their name for more than they needed so that he could use that money. And now his children were saddled with student loan debt, and he promised to pay it back, but of course he never did. So we brought that all up. The children were now adults. They could testify to that. And I was able to get a very substantial unequal distribution based on that depletion and dissipation and total disregard for anything that was going on in the family, except for the financial part of it. And of course, the court always puts this in there. They always like to put this in everything that they evaluate. And any other factor, oh my gosh, that could be anything, right? So that's kind of open game there. What I usually do is try to throw in anything that maybe there was some kind of, what do I want to say, extramarital affairs or anything, and we'll talk about that a little bit in alimony. Florida doesn't really punish you per se for an extramarital affair, but they could, if that person that had the extramarital affair was spending resources and depleting resources of the marriage, could certainly be a factor in putting towards the equitable distribution. Now, you may ask me, what's a marital asset? What is a marital asset? Well, anything. Marital assets and liabilities include anything that was acquired during the marriage. People, I sometimes really have people say, well, the business isn't marital because she never worked in it. She does not have to work in it. Your other spouse does not have to work in the business for it to be a marital business. As long as the business was started during the marriage and was open during the marriage and marital funds were going in and out, in and out, and marital funds, I mean, okay, you have this business, you're paying the mortgage. That's a marital fund. You're paying for everything. Any income that comes into the marriage is considered marital. Whether or not one spouse stayed home, one worked, it doesn't matter. Anything acquired. Liabilities, same thing. Anything that was done during the marriage. Now, sometimes a court will take, like I said, unequal distribution, any depletion or dissipation, meaning you went out and just went hog wild on that credit card, knowing you were going to divorce. Or you maybe forged your former spouse's signature. That might be difficult to prove, but you forged your signature to get that credit card or that liability. That could be something that's argued. Of course, it's the person's burden that they feel their signature was forged to prove, which forgery can be kind of difficult to prove. But anything, either acquired individually or jointly, acquired during the marriage. So we'll always say, okay, what did you have the date you married, and what do you have the date you filed the petition? Marital, right? Marital. Now, also included marital is any enhancement of value of any property, meaning any passive appreciation, like a home. You just sit there and a home can increase in value, right? That's passive appreciation. That's marital. Any increase in your 401k or your retirement, that's passive, meaning any interest or anything that's on there, any dividends, that's marital. The pay down of any principal on any mortgage that brings the value, that's an active appreciation that brings up the value. Although we all know it takes so long to pay off your mortgage, right? I mean, you're mostly paying interest. So you could be married for 10 years and only paid like $5,000 down on the note, but it's $5,000 that could be in your pocket. So, it's better that than nothing else. But anyway, the court, what they look is they also look at interspousal gifts. Now, your husband gives you something, they could claim it as marital, the value of it. I know it's crazy. You would expect that your husband or your wife or your spouse gives you something. It shouldn't be considered in there, but it can be considered in there as some value towards a marital asset. Also, any rights that are vested in a pension plan. I'm trying to think of who has a pension. Oh, like the state of Florida. If you're working for the state of Florida, let's say you're a teacher and you're getting some kind of pension, and your pension vests during the time of marriage. That vesting is also a marital asset. So that's just kind of a list of, it's not all inclusive because, of course, there's always any other stuff that can be included in that, but it's always an argument, to the court as to whether or not they would agree that it's marital or non-marital. There's, any personal property too, like furniture. I don't know. I do have people that fight over furniture. Furniture is a nothing to me. Furniture is like nothing. It's really worth nothing. If you went out and sold it, if you went and I sold this desk at a garage sale, I'd probably get maybe $50, and I don't even remember how much I spent on it, but all that stuff is kind of nominal. Anyway, non-marital assets. I get this a lot. What is a non-marital asset? Anything acquired before the marriage. So let's say you have a piece of property that you owned before the marriage, before you got married, and then you married. So what the courts would look at is the value of the property on the date of marriage. That's your pocket. That is your pocket. That is something that that is not considered a marital property. But of course, let's say the value of the home is $50,000 at the date of marriage. That's not considered. But any passive appreciation, so the date of marriage is worth $50,000. 5 years later, when you divorce, God forbid, it's now worth $100,000. So, or $150,000. That whole $100,000 is marital, and the pay down of the note. So anything acquired separately, there is generally inheritances. Now, an inheritance, you get an inheritance. Let's say you get a substantial inheritance. You put it in an account and you leave it there. You don't touch it. You don't do anything to it. It just sits there. That's non-marital. But if you start taking money out and using it in the marriage, now it becomes marital. Or you even put $1 in that account of marital money, it's now marital. So you got to be careful how you treat those inheritances. Although nowadays, my parents say, hey, we'd rather give it to you with warm hands than cold hands. So, people are giving away their inheritances nowadays. But I still have some people that come to me with inheritances. So any income derived from a non-marital asset during the marriage, unless that income again comes into the marriage. So you had that home during the marriage, right? Or before the marriage. Now you're renting it out. There's income coming in and you're using it to pay marital bills. Guess what? You've now made it marital. So, and again, we talk about, any forgery or anything is, that would be a non-marital. If you could prove it, again, that's very difficult. Now, I know you heard me say the value of a non-marital is assessed at the date you marry, correct? So whatever that is, that's what the value of the non-marital property was at that time. And then you heard me say to the filing of the petition when the court looks at the value. So what the court does, the cutoff date is actually when you file the petition. So I always get from people, if they have non-marital property, I get, okay, what was the date of when you married? I need proof of what the value was or what the amount of the liability was or whatever it may be. Then I need the value of the property on your date of filing your petition. So let's say you married in, just because I'm so bad at dates and everything, you married in 2020. So I need the value of the home in 2020. You filed the petition and actually went through with the petition. I actually had a client that they filed a couple times, but they kept dismissing it because they wanted to work it out, which God bless them. But in the end, they ended up divorcing because they filed a new action. So he kept wanting to go back to that date of the original filing of the divorce that was subsequently dismissed because they didn't go forward. I said, you can't do that. You cannot do that. It has to be when you're moving forward, when the case is moving forward. The court can't keep going back to different dates and doing all that. So they look at the date of filing the petition. So you file the petition January 1st, 2024. I need the value. I need the pay down. I need the liabilities from that date. So from the date of marriage to the date of filing for non-marital. For marital, I just need the date of filing. I just need the value or the liability or the amount on the date of filing. I'm like pounding on my table because I can't tell you how many times I've had to say that over and over again. Well, no, I have this and I have that. And yes, as attorneys, we do ask for more than from the date of filing. We'll generally, when we're requesting financial documents, and just to let you know, we have every right to do that, we will go back 3 years. Just so we can see. I mean, if you've been married that long, of course, if you haven't been married that long, we'd only ask for the length of marriage, but 3 years. So we can look at, okay, what's been going on? Where's money gone? What is the true income of the parties? All of that. So we ask for bank statements, tax returns, paycheck stubs, everything, mortgages, anything like that when we're doing a divorce. So the date for determining the assets and liabilities is the date you file the divorce. The date and if you go through it, it's not going to be subsequent. It's not going to be, oh, but I filed back in 2000, but we didn't go through with it. I want to go back to that. No, you can't. It's the date of filing and you're going forward with it. So just a little tidbit for you. Okay, so that's equitable distribution, how we divide our things and stuff. Again, everything I just told you is if you have to go in front of a judge. Again, if you do a marital settlement agreement, your assets and liabilities, your things and stuff can be divided how you see fit. As long as it's legal, you can do it as you see fit. Now, the second thing I'm going to talk about in the marital settlement agreements is child support. Again, child support is a hot topic. Here in the state of Florida, we pay child support up until the child is either, whichever is later, I'm going to say whatever is later, the age of 18, graduate from high school, or the age of 19, as long as they're going to finish high school. Some kids are held back or something, so they don't graduate till they're 19. I was a baby graduate. I was 17 when I graduated. So if somebody was paying child support for me, they'd have to pay. I graduated at the age of 17. They'd have to pay till I turned 18, because that's the later. We always look at the later. If 18 is the latest, they pay till 18. If graduating from high school is the latest, then they do that. Or if 19 is the latest and they're progressing towards ending high school, then 19. So it's always the latest. What I get a lot also is what do we look at as income? I mean, I get this bonus once a year, but that shouldn't be counted because I don't know how much it's going to be. I don't know when it's going to be. Or I get this a lot from restaurant managers. They get bonuses every quarter or something. Oh, I don't know what the amount is. Guess what? The state of Florida looks at your income, your base income, whether that is salary or wages, your bonuses, your commissions, your overtime, your tips. If you claim tips, I can't even remember. It's been so long since I worked in a restaurant. Business income, they can go through your business records. This is the other side, of course, if they feel that your income you're not being truthful about your income. Disability benefits, workers' comp, unemployment, pensions, retirement, Social Security, any alimony received either from a prior court order, maybe another divorce, or the alimony you're going to be receiving in this divorce. That can be used. Any income from royalties, anything like that can be considered income when we're calculating child support. So when you say, oh, I only get bonuses this often, doesn't matter. I only work overtime. What we generally do is we take what do I want to say, an average for the year. So let's say we're only in April right now. So we would take the average over the last few months and figure that's what you're going to be making. Whether you got the bonus, whether you didn't get the bonus, that's what we're going to look at. So that's what we look at for both parties. Now, what if one party's not working and they don't have an income? Well, then the courts look at it as, are they underemployed? Meaning, did they voluntarily quit their $200,000 a year job to make minimum wage so that they wouldn't have to pay child support, or they wouldn't have to pay a lot of child support? Well, that's not going to fly. We call that underemployment. So you're going to be either imputed. We can impute minimum wage, which is now a lot more, or we impute you from what your history of your work history has been. If your history has been you've continuously and consecutively made $200,000 a year, and now you're not working because you voluntarily quit, we're not going to impute you at minimum wage, because why would we do that? That would make you underemployed or make you have less money. So we can look at, your job history, what a person in your position can make with your education, your training, your certifications. We can do all that. Now, incarceration is not voluntary unemployment. It's not. I've actually had other spouses that have been incarcerated in prisons. And actually, I had one that appeared. Well, no, I take that back. I've had two that have appeared by phone for a trial, for a divorce trial, and they've been in prison. And actually, the court can order that person to pay child support. It can accrue while they're incarcerated, but it can be a lower amount than was actually calculated. I had one where the wife was asking, there were children in child support, and actually the incarcerated parent's family was providing the wife with a car, was making the car payment and also the insurance payment. And the court did count that as child support as long as the other family was paying it. So it was kind of interesting to hear that. I went, oh, that's a creative spin on things, but okay. It is money that's coming out of maybe not the father's pocket, but the father's family pocket. So it was kind of seen as coming from the father. So incarceration is not, a voluntary, oh, they're voluntarily unemployed, they're in prison for 10 years. It's not how it works. Anyway, how do we calculate the income? How do we get to the income? We put up it's a mathematical equation, just to let you know. There's no like, okay, I'm going to pay 30% of my income. It's a mathematical equation, because if I had to calculate it based on any kind of mathematical equation, I wouldn't be able to do it. So it's a mathematical equation and a program that we use. Most everybody uses a program. There may be different types of programs, but they are programs. So we put the gross income. So your gross income is 100,000. That's what you're making an hour, or that's your salary. Then we subtract. Of course, all allowable deductions. Federal, state, local income taxes, adjustment for who's going to be claiming the children, any other dependents, all of that is put there. Maybe if you have mandatory union dues, we don't have a lot of unions down here, but mandatory union dues, mandatory retirement payments, health insurance payments, but health insurance payments only for you, not covering the children. We'll address that in a separate issue in just one second. But health insurance for children is separate. So we put down what the health insurance is just for you. So I always have my clients, hey, call up your HR, get some printout from your HR department to find out what it is just for you. Sometimes it's individual, sometimes it's individual family, sometimes individual plus two, whatever it is, just individual. Any court-ordered support, meaning court-ordered support you're paying for other children. If you have a child support order for another child, that comes out. Now, if you just say, well, I have these children that I support at home, or I have these children that live in California that I support, that doesn't matter to the court. It has to be a court-ordered child support. I always tell my clients, the first person to get that court order gets the first bite of the apple. They get the most income. They get the most support because they're taking the first bite at the apple. The second bite, let's say, is a subsequent child that comes in and wants child support. That amount that he's paying the first child is now no longer part of his income. And we're just going off the income now minus that. So any court-ordered child support that's out there, that comes off as well. And then any spousal support that's paid. So if I'm the husband and I'm paying spousal support to somebody, court-ordered spousal support, either in another relationship or in this one, then that comes off. And so that income, actually, if you're going to be paying your spouse that you're divorcing alimony, that alimony amount actually comes off of your income and goes to the spouse who's receiving its income in the calculation of child support. So sometimes people forget about that, hey, we're taking $500 a month in alimony and giving it to the other parent or the other spouse. Okay, we also, in calculating child support, so that's how we get the net income. Blah, 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 all that's taken out, boop, pops out a net income. So let's say your net income is now $50,000 after everything's said and done. Well, we also look at childcare. Okay, do these children need childcare? If they need childcare, then we take off whatever the childcare. Now, the childcare costs are for work, education, anything like that. Not just putting them somewhere, for the heck of it, anything like that. If it's to further work, education, all that, then that's when we take childcare into consideration. Now, we don't take child care of some 15-year-old because a 15-year-old doesn't need child care, but child care of younger children that require it. That is to be split between the parties. So we actually put that amount, let's say, I don't know what daycare is anymore. I can't remember, it's been so long for me, but let's say it's $250 a month. I know some of you are probably rolling over because it's probably more than that, but let's just say it's $250 a month. It's actually put into the equation because each party is responsible for a portion of that. Then we look at health insurance for the children. You both are responsible for that. So how much is it just for the children? Just for the child, just for the children? That's put into the child support guidelines to calculate, because again, you both are responsible for that. Finally, we look at the number of overnights. The overnights, how many overnights do the children have with each parent? So, what we look at is, let me just tell you this, the more overnights you have with the children, what do I want to say? The lesser the child support. So if you have, the minimum is like 20% overnights. That's about 70 overnights a year. That's when you start going above that 20% is when the child support starts coming down. So if you only have 10 or 15% of overnights, you're going to pay the maximum child support. But once you start edging up that 20%, then the child support starts coming down. Now, I'm not going to say it drastically drops, but the more you spend overnight, the lesser it's going to be. Now, I get this from parents all the time. Well, I want 50-50 time sharing. There should be no child support. Not the case. I have many, many, many cases. You have to do the calculation. You have to do the child support calculation. So if you're doing 50-50 time sharing, there may be some child support there. Now, it may be a very small amount. I call it de minimis. If it's de minimis, then I'll ask the court to waive it. I mean, it says $50 a month. I mean, come on, that's not even worth the paper. But if it's something, substantial, you never know, because there could be a big discrepancy in the incomes. Then there could be child support needed in a 50-50 time sharing schedule. So overnights are important. They bring down the child support the more you have, but it doesn't eliminate it potentially altogether. So once we get all those numbers in there, we get your net income, we put any child care, we put any health insurance for the children, we put in the overnights, we press pound, and out pops a number. And that's the number or the amount of child support that's supposed to be paid from one spouse to the other. And I know what you're thinking. You're thinking, well, no, I mean, the man always has to pay the child support. I've had several cases where a woman has paid the man the child support. So you never know. Like I said, that's why it's always smart to get an attorney and not just figure, okay, I'm going to agree to $1,400 in child support. No, don't do that, because you don't know what the calculation is. Also, child support can go retroactive. Let me explain to you what that means. In a divorce or in a paternity action, retroactive means from the date of filing the divorce. Again, we're looking at the date, January 1st, 2024. The courts and the spouse requesting it can ask for retroactive child support 2 years prior to filing of the petition. Of course, there's several factors. Know this, that just because she's asking for 2 years prior doesn't mean she's going to get it or he's going to get it. Because what if you were living together up until 12 months before you filed? The court's not going to make you pay retroactive if you were living together because you're sharing the bills. Or you were paying child support and you have proof that you were paying for child support. So we can ask for 2 years prior, retroactive to the date of filing. But of course, there's several factors that can cut that down or eliminate it altogether. So I always have to break it to my clients when they come to me. Okay, when did you separate? When did you move out? Okay, have you been paying anything for child support? Please start paying something so you get credit for it. And also, I also tell my clients, if they don't pay it through the court, pay it by either a Zelle transfer, Venmo transfer, bank transfer, check, so you have proof. Because I'm telling you right now, if you give cash, what's going to happen when they go to court? He didn't pay me anything. And how are you going to prove it if you paid cash? You watch Judge Judy. I watch it all the time too. So make sure that you keep proof of that for retroactive child support and ongoing if you're not paying it through the court. Okay. So that's child support. Child support is for support of the child. That you both are responsible for. Whether you see the child or not, you're both responsible. That's something that we generally put in a marital settlement agreement. If you guys see the numbers and you agree to the numbers. A lot of times I get a fight on the numbers and I say, listen, it's just based off of income. Sometimes the income is in dispute, especially if somebody owns their own business, and all that comes into play with child support. So The next topic we're going to talk about, I'm a numbers lady today, is alimony. Whew. Let me tell you, alimony has had an overhaul this year in Florida. In 2023, we abolished permanent alimony. I shouldn't say we. The state of Florida, our legislature, and Governor DeSantis abolished permanent alimony. What was permanent alimony? Permanent alimony was if you had a long-term marriage, you could get alimony for the rest of your life. Until I died, I could get permanent alimony. So that's what permanent alimony was. Well, it's not that it couldn't be modified, of course. If somebody retired or lost their job or something, it can always be modified, the amount, but it was for life. If I died or I remarried, then it could stop. But we no longer have permanent alimony. We now have a fixed number of years. And let me go over that with you. There's several different types of alimony in Florida. No longer permanent, but there are several types. The first type, of course, is temporary alimony. There's bridge the gap. There is rehabilitative, and there's durational. So let me go into what those types are. First of all, what the court does when they review whether or not an award of alimony in any of those forms should be awarded is what is the need of the person requesting the alimony? And what is the ability of the person that's going to have to pay it? What is their need and what is the ability to pay? Now, is it the person's job who is fighting the alimony award to say that, oh, listen, they don't have the need and I don't have the ability to pay? No, it's the person asking for alimony. It's their burden to prove their need and the other party's ability to pay. If they successfully achieve that, now it flips to the other side where we have to prove, okay, well, she really doesn't have the need and we really don't have the ability to pay. So that's the first kind of element that we look at when we're deciding on, when the courts are deciding on alimony. So let's say they were successful in overcoming that part, that element, need and ability to pay. Does the court say, okay, let's calculate alimony? No. The court takes several things into consideration, much like they did with equitable distribution. They look at the duration of the marriage, the standard of living established during the marriage. You know, did you go on a ton of vacations? Did you live in glorious homes? Did you have nice cars? Did you live, gloriously? They don't want you now, okay, now I'm homeless. That's not how it is. So they look at that. Now, if you were living that way and you're heavily in debt, they'll take that into consideration. They also take the age, the physical, the mental, all of that emotional condition of the parties. They look at how this is going to affect each spouse. Do they need it for that? How do they need it? Also, the resources and income of both parties, the earning capacities of both parties. Does somebody have an education and somebody doesn't? Did somebody give up their education or give up their job to encourage the other one? The contribution of each to the marriage and the responsibilities of each party when it comes to child rearing. Are there any special needs children at home that need to be taken care of? And then, of course, as we always like to do here in the state of Florida, and any other factor that may be out there. So I did tell you now the terms and the length of marriage in Florida have kind of changed up a little. They've kind of gotten a little longer. Short-term marriages used to be like up to 7 years. Now a short-term marriage is anything from when you marry up to 10 years. A moderate marriage is anything between 10 and 20 years. It used to be like 17, 18 years. A long-term marriage is anything over 20 years. And so the length of the marriage and how we calculate it is we calculate it from the date of marriage till the date of filing the petition. Not further on, but the date of filing the petition. So if you've been married for 10 years, from the date of marriage to the date of filing petition, you're a moderate marriage. But let's say you don't get divorced until 2 years later. They're not going to say, oh, you're married 12 years, blah, blah, blah. No. It's from the date of filing the petition. Now, the forms of alimony are, like I said, temporary, just temporary to get you kind of through the divorce proceeding. Maybe the breadwinner has left the house and now, you don't have any money. The court can order some temporary alimony just to kind of get you through. The burden's not so high. There's a need, ability to pay, all of that kind of stuff just to get you through. And of course, the payer will get credit for paying that. There's bridge the gap. Bridge the gap is to help an individual get from being married to being single, just to kind of get over that hump, to go, okay, let me figure out what I need to do. And that is generally for short-term needs, not for anything long. And it cannot exceed more than 2 years. So you can't be on bridge the gap alimony for 10 years. You can't. It's only for 2 years, just to kind of get you through and get you used to what you need to do. Now, rehabilitative alimony may be awarded to assist a party in getting the needed education, training, job that they need to get back into the workforce. Maybe I've been home for 10 years as a lawyer, and now I'm going back into the workforce, and I'm like, oh my gosh, what do I need? I have no idea. I haven't practiced law in 10 years. I need this training. I need that training. That's what rehabilitative alimony is. However, you don't just to go and say, okay, I want rehabilitative alimony, blah, blah, blah. You have to have a rehabilitative plan. What is your plan? I had one for a client of mine a million years ago. She wanted to become a medical transcriber. And apparently it would take her 3 years at the time to get that training, then another year to get a job and to get working and stuff. So the court did order 4 years of rehabilitative alimony because she was needing to go to school, purchase books, get into the job market, all of that. Now, rehabilitative alimony cannot exceed 5 years. So also rehabilitative alimony can stop if you don't follow the plan. If you say, well, I'm just getting alimony, so I don't need to go out and get my skill or redevelop working or anything like that, the person who's paying you can say, hey, wait a minute, you're supposed to be doing this and you're not. And so I'm going to go to the court and I'm going to say, hey, she's not following her rehabilitative plan. Why am I paying for a rehabilitative plan if she's not doing it? And, you'd show the court that they're not doing it. They're not doing what they're supposed to do. They're not be training. They need to be self-sufficient. The court could minimize or could eliminate it altogether. So last but certainly not least is called our durational alimony. That is now the new, the takeover of permanent, because there's no longer permanent. Durational alimony used to mean that it was a duration of the marriage. If I was married 10 years, I wanted durational alimony for 10 years. If I was married 9 years, I wanted for 9 years. That's what durational alimony was. Well, not anymore. Durational alimony is to provide for economic assistance to a party for a set period of time. And it terminates upon the death or remarriage of that person. Now, when the court is looking at awarding durational alimony, first of all, they're going to look at the economic circumstances and the elements that we went through, need and ability to pay, obviously, and the factors. But they're also going to look at the length of marriage. And when they look at the length of marriage, they cannot give durational alimony for a marriage of less than 3 years. I mean, they just don't. That would be something like bridge the gap or rehabilitated if you needed it. But durational looks at the length of marriage and gives you a percentage of years. So you no longer can get the full duration. So if you're in a short-term marriage, meaning 0 to 10, you get 50%. If it's awarded, if the court awards it, you get 50%. So you get 5 years of alimony at the most, because that's 50% of 10 years. If it's a moderate term marriage, 10 to 20. Let's say you've been married 15 years, and I am not a mathematician, so you'll have to do this math on your own. You're only allowed 60% of the years you were married. So maybe that's like, I don't know, maybe 8 point something or something like that, or 7 point something years that you would get that durational alimony. And then if you have a long-term marriage, meaning anything 20 and above, you only get 75% of the years that you were married. So let's say 20 years or 21 years, that would maybe be, I don't know, 17, 18 years of alimony that you would get. You only get 75%. Before the new law, a long-term marriage was you got permanent. You got permanent. Now you only get 75% because there is no permanent alimony. Now, okay, so obviously in considering alimony, what they're going to do is they're going to be determine both parties' incomes. And so what the court looks at after all this has been said and done, and they've gone through all these factors and the number of years and how many years you're going to get, they have to calculate an amount. Now, how I always do it is I what do I want to say? I present, this is what my person needs in alimony for, to pay the rent, to pay a mortgage, to do all that. I always like to present that and justify what amount I'm asking for. Now, if you're not asking for an amount, you just want the court to award an amount, which I really wouldn't put it in the hands of the court, but I would at least put something forth. They're going to be determined not to exceed, you cannot give the other spouse more than 35% of the other spouse's income. They have to look at least somewhat equal. They can't be like this. And you can't, what do you want to say? Rob Peter to pay Paul. You can't make the paying spouse make less than the one who's receiving it. You can't do that. They have to be somewhat equal. So you can't take more than 35% from the payer's income. And you cannot leave the payer with less money. You just can't, you can't rob Peter to pay Paul. Also in alimony, like I said, in equitable distribution with an unequal distribution, the courts can look at any, how do I want to say this, unfaithfulness of one party in the marriage. So if the one party was unfaithful, had an extramarital affair with somebody, and was paying for an apartment or buying cars or spending a lot of money on hotel rooms or anything, or lavish gifts or trips or vacations, and dissipating, like we talked about above, dissipating the marital assets and all of that, or creating these lavish liabilities that he's claiming are him or her claiming now as marital, the court can look at that as well and awarding an alimony amount, saying, hey, you dissipated this asset. I'm going to put it on an alimony. You need to pay her back in an alimony award or an equitable distribution award. So they can look at that. Again, the court is not punishing the individual for having an extramarital affair or being unfaithful. They're just saying, hey, you were unfaithful. You spent this much money of marital money on this extramarital affair. We want to pay back the one spouse for the money you took out because of your missteps, I guess we would call them. But anyway, so the court can do that. Also, I just want to touch a little bit on attorney fees. A lot of times we'll ask for attorney fees that one party pay the other party. Again, the court does the whole mathematical thing of need, ability to pay attorney fees on the other side, going through the factors, the reasonableness of the attorney fees, of the attorneys asking for them. The court goes through all that gymnastics, and they'll look at attorney fees at the very end, because if the payer has now paying alimony, is paying child support, there's been an equitable distribution, all that, a lot of times the courts say there's nothing there to pay attorney fees. I had a judge one time tell opposing counsel, who was very nice, he was asking for attorney fees, and my poor client was paying alimony, child support, all that stuff. And the judge looked at the opposing counsel and said, I'm so sorry, but I can't award attorney fees. There's no money to be had for attorney fees. He goes, I apologize. I was in your seat at one time. I know this is a blow, but there's no award for attorney fees because there was nothing. How is he going to pay him? He's already paying all this other stuff. So the court does look at attorney fees. They do take into consideration everything at the end of the day, what's been divided, what's being paid, and then decide attorney fees. So they don't decide that at the beginning because they don't know what's going to flush out. So Anyway, I'm glad that you joined me. I hope that you got a lot of information. I hope that this really helped you. And please, please, please give me a call if you have any questions whatsoever. I'm more than happy to help any of you in the state of Florida. And I'm so glad that you tuned in. And I hope to see you next month. What is it? May? May? Is it really May next month? Oh my goodness. May. What is it? April showers, spring, May flowers. I'll see you in May.